Sound check? All right. My name is Mike Schroeder. I'm Trung Nguyen's attorney in the just completed trial for the recount. The judge's ruling is not a surprise, and as everyone has said from the beginning, this is a matter of the first time the court actually having to decide an election contest where electronic votes were recounted and the method by which they have to be recounted. And everyone has anticipated that whatever was decided here, ultimately this is a matter that is resolved by the Court of Appeals. Of course, we have to take a look at what the judge's ruling. I anticipate, though, that we will be filing an appeal for emergency writ, and we expect that will probably be resolved by the Court of Appeals in about 30 to 40 days. That, of course, is up to the Court of Appeals, but that's typically the time frame these things would occur on. As for the swearing in for Janet Nguyen for tomorrow, Trung Nguyen's position has been consistent. His position has been that whoever the judge deemed to win the election contest today should be sworn in tomorrow. The seat should be left open for 30 to 40 days. So when the motion comes before the County Board of Supervisors tomorrow to have Judge Brenner sworn in, we will, of course, not oppose it. That doesn't mean, of course, if the Court of Appeals doesn't agree with our position in the next 30 to 40 days, that they won't declare a different winner. It just means for the next 30 to 40 days, Janet Nguyen will be the supervisor for the first supervisor of this question.
Is Trung Nguyen ready to concede at this point?
No. I mean, there's nothing really to concede here. It's simply a straight legal question, which is, can you switch recount methods in midterm? We respectfully disagree with the court on that point. And the second question is, for electronic ballots, where there's a paper version of it, do those have to be counted or not? We respectfully believe that the statute that says those shall be used in any full recount means that they shall be used in any full recount. And that's what we'll ask the Court of Appeals to determine.
What about the judge's point that those paper copies of the electronic votes wouldn't really tell you anything anyway because they're under the screen with the judge?
Well, I mean, with respect, we just disagree with Judge Brenner on that point. I mean, for one thing, there's evidence in the record that these machines make mistakes, and the electronic record is not always accurate. That's why the legislature specifically passed a law that says if the electronic record is inconsistent with the paper record, that the paper record shall control. Why would you have a paper record if you don't count it? In this case, it wasn't counted. We believe that it should be, but ultimately the Court of Appeals will let us know what they think.
What was Trump's reaction?
Well, you know, he's disappointed. He's disappointed by this. His instincts are to file an appeal, but you know, we'll spend a day or two reviewing what the judge ruled, and then we'll decide. I mean, he's been at this for a long time. I mean, the election was back in the first Tuesday in February. We're almost to April, and this issue's still going on. So it's been a wearing thing. It's been a bit of an emotional drain, but he's dispirited. Well, I mean, the judge basically wasn't willing to characterize it as gaming, but he did agree and find that they did change counting methods midstream. We believe the law is clear that you can't do that. The minute you start allowing someone to count, change the way you're counting, you go down a slippery slope that you cannot recover from. Because what happens here is, if you allow one change in the counting method, why not allow precinct by precinct, depending on what precinct you did well in, and you want to keep all of those, so you run it through by machine, or one your opponent did well in, where you go through and you count them manually looking for stray marks on the ballots to disqualify. That's what happened here. Analytically, once you go down that road, I don't think the road will come back from it. I don't think the legislature needs to do anything here. With respect, I believe that the law is crystal clear in this area, and a statute that says you shall use the paper, voter verified paper autograph for any full recount means just what it says, and I don't think the legislature needed to put it in more clear than it were.
Mike, this is to fill Senator Correa's unexpired term. Is your guy ready to go again on that coming back open?
You know, it's premature at this point to talk about an election 2 years from now. In the universe I live in, that's almost like 3 lifetimes from now. His focus is he believes that he actually won this election. He certified as the winner on election day, and we believe there was never a full recount on the And, at this point, I don't think he's prepared to make a statement himself, other than what I indicated for him, which is that he does anticipate at this point filing an appeal, but we'll spend a couple of days reviewing it before making a decision.
So as the recount stands, it's just 7 votes.
Actually, as the recount stands, it was finally certified as 3 votes. A 3-vote margin was the final margin that the judge certified. Any other questions? Actually, in this circumstance, the judge is the registrar. He actually certifies the election and declares a winner, which is what he did. Subject, of course, to what the Court of Appeals says.
Unbelievably close.
It's the closest race in Orange County history, particularly for anything for county office. We had over 42,500 votes, and ultimately it came down to 3 votes. Essentially, what Orange County did is they flipped the coin and landed on its head. Thank you.